you got out of high school, you traveled here in Gainesville, traveled around the world. He started out as surfing, a surf bum. Went to Hawaii.
Wait, you a landlocked Gainesvillian into
Yes.
surfing? Okay.
And then you go to Hawaii. Here, he went around the world. He met his wife, and she's from Sweden. So he married her, and we all went to Sweden. And then my older brother, who's kind of shy and quiet, he always tagged along. But after 20 years, my older brother married her best friend.
Wow.
So I
Wow.
have two sister-in-laws that are Swedish.
Wow. How interesting. How did the surfing work out for your?
Male, no, oh, I didn't know you can get compliments from male.
I didn't either.
Tampa. But then he came back to start his own construction company,
Oh, wow.
and now he's retired.
Oh, okay. Right. Right. Yeah. Most families have tail like Miami. So for so oh, I'm usually okay, but I appreciate it. Thank you very much. I'll probably just spill it. Promise not to hover.
Once we go, I quit sharing. I can, oh my God, not already. Usually when I go to do that, like people go, then when I go back, quit sharing, it's 10 teachers.
Danae. You run a tight ship. That's what I do. The students want to wander in late. That's no problem. Sure. No, no, no. Ah, Yeah, that would make sense. Well, microphone, hold up your mouth. I'll do that. Thank you.
Okay, we'll go ahead and get started. Welcome. Thank you for coming. If you're in the room and have a cell phone, if you can please silence it, would be greatly appreciated. People on Zoom, you are muted. Please stay muted until after the presentation. You can put any questions you have in the chat and I'll monitor that for you. And Danae is here and she's going to introduce our speaker.
Thank you again, as usual, for coming. This is the fourth in our six-part series, and I'm really pleased to present my colleague, Lars Noah, who has been at the law school longer than I have, which there's not very many of us left that have been there as long. But Lars, is the Chesterfield Smith Eminent Scholar Chair. He at the University of Florida's Levin College of Law. He teaches administrative law, medical technology, public health law, and torts, has a slew of case books and a slew of articles. He's one of our most cited, most published professors. He went to that Florida of the North for both his bachelor's and JD that we don't really want to talk about, but they're currently suing the Trump administration. Yeah. And he's been around for a very long time. But before I turn it over to him, I'm sorry, I didn't do this first. Our speaker next week, we will be talking about recent Supreme Court decisions. And our speaker, Gary Lawson, who was scheduled, will not be able to make it. So I'm working on a backup. But I don't know who it will be just yet. Hopefully it won't be me. So with that, I'm turning it over to Lars. Thank you.
Thank you, Danae. Someone I helped hire. I've been teaching here at the law school for 31 years. I am a native Floridian too. Grew up born and raised in Coral Gables near Miami. So thank you for having me. It's a very impressive place you have here. I haven't had the occasion to visit before. And I've been asked to talk about vaccine mandates. This template for my introductory slide, you may wonder, why isn't it a law school template? I'm not even sure we have a law school template. For a year now, I've been a member of the EPI at UF, the Emerging Pathogens Institute. And I decided, since I haven't taken advantage of any of the member benefits, I thought I'd download one of these things to add some color to my presentation. And vaccines, of course, are very much within the bailiwick of that group. Now, before COVID came along, and there's no way that you're going to be able to make sense of this, I was primarily interested in the work of the US Food and Drug Administration, the FDA. So questions about how therapeutic agents and prophylactics, vaccines, are designed, manufactured, labeled, those were the sorts of things that I paid attention to. This slide is a quick and dirty summary of where the oral polio vaccine comes from, how it is regulated, how it is licensed. I paid fairly little attention to what happened to vaccines and the like after they got out into the marketplace. That was somebody else's problem, okay? But then with the pandemic, it was hard not to start paying attention to those sorts of issues. And my hometown paper, not the Miami Herald, the Boston Globe, I lived up there for 6 years, rooted for the Bruins, as you must, contacted me. A reporter was curious for my thoughts on what at the time were university vaccine mandates. So the COVID-19 vaccines were a few months old at that juncture. and places like Rutgers, for example, and Indiana, among other university systems, public university systems, were giving some thought to the idea of forcing students to get inoculated before they could come back for the fall semester. And the reporter did point out that I was an FDA person, not a CDC person, by and large. But by being an FDA person, I knew that the COVID vaccines had come into the marketplace following an unusual pathway, one that was hardly ever used before. It's called the emergency use authorization. It's a quick and dirty, less than full approval process that ultimately may lead to full approval, but wasn't quite there yet. And I also knew that there was a peculiar federal statute that might get in the way of vaccine mandates before a particular agent had gotten full-blown approval. Okay? I did concede that once they got full approval, this issue, the statutory consent requirement, fell by the wayside, and I knew enough about the constitutional issues to feel fairly confident that those wouldn't get in the way either. I will suggest to you this afternoon, I'm not so confident anymore about that caveat, but we'll get there. The other thing, though, to take seriously is the understanding the motivation. What was driving the increasing interest, first among universities and then among any number of other players, and we'll see some of the resulting litigation in subsequent slides. Well, it was frustration. It was, we're tired of Zoom, hybrid classes, things like that, teaching behind plexiglass. We want to get back to normal, and the vaccines seem to offer a ready-made way of trying to get back to business. Okay, so I did, in my remarks to this reporter, concede that there's good reason to want to do this, but that maybe these public universities were jumping the gun just a bit. What they were proposing to do, to my mind, was a violation of federal law. Let me emphasize, to my mind, because the reporter interviewed a handful of other experts who took a contrary position. So I was kind of the lone dissenter in this news article. About 5 weeks go by, and another reporter reaches out to me from USA Today. But this guy wasn't interested so much in university requirements. His focus was on businesses and also state and local governments getting into the business of mandating, requiring vaccination. And here again, I repeated what I said to the Boston Globe reporter. These are not yet fully approved vaccines, which under federal statute creates a problem. There is a barrier, a requirement that persons exercise free choice, that they have a right to refuse that Congress made pretty explicit now 22 years earlier. If you can tell from the head for this online news piece, federal law does not prevent states, businesses. So clearly, again, I was a minority of one, and the reporter decided I was hardly worth noticing. And that got me frustrated. So much so that 3 years later, I decided it's time for me to do this properly, to write up a full-blown academic piece, brought along a reprint here, just got published last fall, where I explain why I had originally taken that position and sort of confirming that I was pretty sure I had it right and everyone else had it wrong. Now, we'll cycle back to that at the very end of my presentation because it really is a minor issue. When people talk about vaccine mandates, it's rarely a vaccine that's just coming into the marketplace. We're talking about long-standing, well-accepted, long ago approved, so that the issues are less about this peculiar federal law. And it's hard, it's a sub clause of a federal law. It's really tucked away, hard to find. Um, so that what I want to focus on today instead is the bigger picture question. It's not just the COVID vaccines, it's any vaccine. And it's not just the COVID mandates that were being tried, it's even broader than that. And that is a different show and tell. So 2 years ago, I decided I need to write a book. It's not just about vaccines. It's a textbook for use in law schools on public health that covers the waterfront, deals with all the many different responses one might have when there are public health problems. Vaccines obviously play a fairly central role in that. In fact, I give you references to the various subchapters, and the material that I'm going to run through in the next 10 or so slides, it would take a good 3 or more weeks of the semester, as I will teach it in the fall semester in law school. So just bear with me. I just want to give you a taste for what the landscape looks like here. Now, this is a long-standing issue. We've had pushback against vaccine mandates going back to the 19th century. This little cartoon, I believe, comes from when Quebec in 1885 decided to mandate everyone get vaccinated against smallpox. They didn't, in fact, tie you up or have a police officer hold you while it was being administered. Instead, you might get a ticket and some sort of fine if you failed to abide by these requirements. It caused a riot. Montreal had a vaccine riot in 1885. Across the pond, I think it was in Leicester, in England, there was an even bigger riot. It was 100,000 people that turned out to protest the fact that the UK government had imposed a similar requirement. Although, if I recall, it wasn't every adult, it was only for school-aged children. And in fact, that's more typical. This is obviously not from the 19th century. This is a fairly recent one out of California. But the oldest vaccine mandates that we have in this country relate to school attendance. And they date back to before the Civil War, many decades before the Civil War. It's kind of unclear exactly when you can say the first one came along. I've seen dates as early as 1809. But smallpox vaccination as a prerequisite for school enrollment is something that we've had for 200 years, let's say. More recently, in the employment setting, workers, particularly in healthcare settings, have been encountering vaccination mandates. And that's been one of the places you've seen some of the pushback in the last decade or so in this setting. And the last one, just by way of illustrating here, it's the customer. It's the vaccine passport idea. You only get to come into our theater, into our sporting venue, into our retail establishment, our grocery store, if you can prove that you've been vaccinated. And that, of course, is something that COVID-19 was really the first place, although there were some smallpox, back in the smallpox era, there were versions of this, but it's something that people really started to pay attention to again with regard to COVID. Now, just to sort of summarize what I was trying to illustrate with those various images, it's important to appreciate that vaccine mandates come in all sorts of different forms, and they are more or less compulsory. And that's actually an important thing to appreciate, how much flexibility, how demanding these in fact are. And I came up with just over half a dozen. There is the everyone in a particular place must get vaccinated. Again, typically there's only a fine that attaches if you don't. You don't get to go to school unless you can prove you've been vaccinated, and you may get expelled if it turns out you're not. And then your parents may face truancy charges. You may be subject to a quarantine requirement. You're coming over on a Cunard steamship into Boston Harbor. There's a famous old Massachusetts Supreme Judicial Court decision along these lines. You can only get off the boat and venture into the city if you first accept a smallpox vaccination. If you don't, we're going to hold you for a number of days. I mean, traditionally, 40 days that's where the word quarantine comes from. With smallpox, it would have been, maybe 10 days or so. But if you want to get out, you only get out if you accept a vaccine. You only get to visit the country temporarily or permanently if you get any number of vaccines. During COVID-19, the top-rated men's tennis player, Novak Djokovic, discovered that they meant business. He couldn't play in the Australian and the US Open that year because he refused to get his jab. And persons who are immigrating to the United States, there's actually in the United States Code, a federal statute, a laundry list of all the things you need to be vaccinated against if you want to come to this country seeking permanent residence. So that's a common place you'll encounter these. The employment setting, as I said before, especially in healthcare institutions, and workers get fired. Workers who refuse to get vaccinated and don't enjoy an exemption have in fact lost their jobs. Customers, persons who want to take a cruise, the cruise industry for a while was trying to require vaccines. You don't get to board the ship. You don't get to come into the venue unless you can demonstrate that you have the vaccines that business demands. And this is a fairly minor one, but it did get some attention. If you want an organ transplant, you better get vaccinated. And there's some people who refused to get vaccinated and were removed from the transplant list. More typically, this shows up in pediatrician practices. Physicians might decline to continue having a child as a patient if the parents refuse to follow vaccine recommendations. Okay? Now, just stepping back, and we'll see examples of all of those in play. Stepping back, one of the things to wonder about is, many of these requirements, it's not exclusively vaccination. So maybe you get a waiver, or maybe you can choose not to get vaccinated, but then you have to do something else. You have to mask, or you have to get tested on a weekly or whatever basis. Or maybe if there is a localized outbreak, you're no longer permitted access to that facility, let's say a school. Does that change our sense about whether or not it's genuinely compulsory in terms of a vaccine mandate if those sort of end runs or options remain on the table? Now, let me give you the quick and dirty overview of what courts have been saying about vaccine mandates over the centuries. The classic decision, it's now 120 years old, comes from the US Supreme Court. It arose in the city of Cambridge, my old stomping ground as an undergrad and law student, where the city decided everybody, adults, children, you name it, had to receive the vaccine against smallpox. There was an outbreak. They were concerned. One guy was adamant, Henning Jacobson, he wasn't going to do it. So he got a ticket. He had to pay $5 as a fine. If you inflation adjust today, that's about $160, but it's still small potatoes. But he was adamant he wasn't going to pay $5, so he went to jail. And he was criminally prosecuted, and he appealed that all the way up to the US Supreme Court. And in a decision that has become the fountainhead for the field of public health law, the High Court explained why he didn't have a leg to stand on, that he, in fact, would be subject to this, as the court put it, compulsory vaccination requirement. Now, it's a fair question. Is it compulsory if you only have to pay a nominal fine? I mean, isn't the court in effect, or the city in effect, saying, you can buy a license to threaten your neighbors after all, at least persons of means, that it would be much more intrusive if the alternative to getting a vaccine was in fact everyone goes to jail or everyone goes into quarantine or isolation. No, instead you pay $5, you're good to go, and you're still unvaccinated and you're still potentially a danger to the community. But in an opinion from, this was the John Marshall Harlan the Elder, he wrote essentially about, we've got communal self-defense. It would be anarchy not to allow government officials to demand sacrifices of people. It's just like sending people off to war. That we make demands for everyone's benefit. It's part of the social compact. I mean, it's a wonderful opinion. It's very rousing language, you might say. And it has come to mean that, in fact, all sorts of intrusions on what people think they have some freedom of choice with regard to might, in fact, be overridden, at least in certain circumstances. Now, notice I've captioned this as pre-modern, and that's one of the things. Nowadays, it's really hard to tell what precedential weight Jacobson has. It's a classic, it's much cited, but it came up at a time before we did modern or contemporary forms of constitutional scrutiny. So there's a lot of back and forth about exactly what proposition that decision stands for. Now, the next one up was Zook versus King. This is a school mandate against smallpox. And Louis Brandeis, writing for the court, a unanimous court this time, made quick work of it. There was no sort of great rhetoric about it was just, hey, Jacobson, end of story, you're done. Even though there were real questions. I think it was 1914 that this is San Antonio in Texas, imposed this requirement. It was only for school children. Adults didn't need to get vaccinated. It wasn't clear that there was, in fact, any circulating smallpox there at the time. They seemed to be picking on the Zucht daughter. They weren't, in an even-handed fashion, expelling other students. And the Supreme Court was whatever. That's it. It would take 99 years, unless I'm mistaken, for the Supreme Court to come back to a vaccine case. Now, there was one 20 or so years after Zucht where there's an important passing remark made. It's called the Prince case, again involving the Commonwealth of Massachusetts. This was a child labor law prosecution, and a Jehovah's Witness was arguing that the state couldn't enforce those prohibitions against somebody on religious grounds who was behaving in that way. And the Prince Court rejected that First Amendment defense. But in the course of doing so, it said, just because you're following your religious precepts doesn't let you skip vaccinating yourself or your child either. And a lot of courts have, taken that to mean that the free exercise of religion does not stand in the way, just like due process and equal protection do not stand in the way of vaccine mandates. Now, let me give you some real quick lower courts. These are not pre-modern. These are all 21st century decisions, but they predate the COVID era. The first several involve schools. And the first one asks whether the city of New York could add flu vaccine to the normal list of vaccines required for school attendance and also extended to pre-K, to childcare, so that these are less about constitutional issues and more about, does this entity, this government official, have the power to do what they did? And in case you can't tell, the little green check mark that says, tells you the court upheld it. Michigan required, like all states require for school attendance, that you get a series of vaccines. You could get a religious waiver, but Michigan decided to make it really difficult to get a religious waiver. You have to go to the health department. You have to be sat down with some nurses who are going to read you the Riot Act. And the court said, nah, no big deal. So that even if there's a burden put in the way of exercising that waiver, that right to an exemption, it wouldn't be constitutionally problematic. This involved a hepatitis B vaccine. Again, some burden. You would actually have to prove that your religion that you follow is against the hepatitis B vaccine. The federal district court in Arkansas said, no, you can't do that. That violates the Establishment Clause. But you know what? We're going to sever it so that you're still subject to mandatory vaccination and nobody gets a religious waiver now. Then we're back to New York and this question of, well, what if you got a waiver and there's an outbreak? So your kid doesn't have the varicella vaccine against chickenpox, and then somebody in their school comes down with chickenpox. The court decides unvaccinated persons can be forced to stay at home. They suffer some consequence for their decision to exercise their religious rights. New York got fed up with the school religious waivers, so that the legislature decided in 2020 to just get rid of them altogether. And in FF, an intermediate appellate court in New York, saw no constitutional issues with that. This to me is the most interesting of this group. Why? It's a mandate that applies to everyone in a community. So it's the closest modern example of what happened in the old Jacobson smallpox case. Everyone living or working in 4 zip codes in Brooklyn, roughly 250,000 people, would have to get the MMR vaccine. Why? Because there was a measles outbreak, a fairly serious one, although it pales by comparison to what we're experiencing right now, mainly in Texas, or for that matter in Canada. And the court decided that, in fact, the city had the power to mandate that everyone in that area. Now, again, you got a ticket. I think there were 120 or so people ticketed, and then you might pay a fine. But nobody was actually forced to pay a fine. So it's a symbolic measure. Nobody was held down or strapped down and forcibly administered the MMR vaccine. The next 3 are private mandates, all in healthcare settings, and all involve the flu vaccine, so that you have workers who get discharged for refusing the flu vaccine and attempt to, in the first 2, claim a religious waiver. And the court in the Fallon case saw no violation of Title VII, which is federal prohibition on religious discrimination. In Head in North Carolina, the state religious discrimination or employment discrimination statute wasn't violated. Again, somebody claiming a right to, I think it was a Seventh-day Adventist, thought there was pork product in the flu vaccine, which there wasn't, and the court found no problem. The one outlier here comes out of Seattle, Washington. A big hospital there said everybody gets the flu vaccine. They didn't run it by their union. It wasn't part of the collective bargaining agreement. They were obligated under federal labor law to go back in and talk turkey with the union before that they could impose that in a way that would threaten discharge. Now back to the U.S. Supreme Court, and now we're talking COVID. So this is in the last 5 years. Most of these are the quick shadow docket decisions. These are not ultimate decisions on the merits after full briefing and argument. They are emergency applications. Something's happened in the lower courts, and one of the parties runs up and wants a quick decision from the Supreme Court to put everything on ice. And we see this happening again in the last 6 months, where the Supreme Court is doing this even more frequently. State of Maine required all healthcare workers to get the COVID vaccines, did not allow for religious exemption. 6-3 decision, Supreme Court saw no problem with that. Ditto in New York. And in this case, Kathy Hochul, the governor of New York, she actually said some fairly problematic things about nobody should have any religious qualms with these vaccines. And even though there was a suggestion of bias on the defendant's part, the court decided no problems there either. The one biggie was the Biden administration's mandate that large employers, those with over 100 workers, force COVID vaccines on their employees, that the Occupational Safety and Health Administration would impose this requirement, and the U.S. Supreme Court decided that's not OSHA's power. Congress did not give OSHA the authority to do that. In contrast, the Centers for Medicare and Medicaid Services imposed a like requirement. This affected roughly 10 million healthcare workers, and in Biden versus Missouri, decided the same day. A bare majority of the court thought that that was permissible. The military was another flashpoint where service members were obligated to get the COVID vaccines. And although a religious waiver was allowed, in de facto, nobody was getting the waiver, and still a majority of the high court decided there's no problem here. Now, just to sort of fast forward, the Biden administration, weeks after the first COVID vaccine got full FDA approval, pushed for a variety of federal mandates, military, CMS, OSHA, we'll talk about a couple of others in a moment. The current administration, of course, is doing the very opposite. In fact, the clearest signal so far is this executive order from mid-February saying schools cannot mandate the COVID-19 vaccine. Of course, no schools were mandating the COVID-19 vaccines, but that tells you that the current White House is taking a very contrary position on this one, like everything else, that vaccine mandates probably not something we're going to see in the near term, at least not from the feds. Lower courts, in fact, one of the reasons I put that textbook together, there were more than 1,000 cases that went to the courts during COVID. That's how litigious the issues became. And it was closures, it was masks, you name it. We're focusing on vaccines here. One of the earliest, Indiana University's requirement, and a federal appellate court says, hey, if a student doesn't want to get vaccinated, they can go someplace else. Just transfer out of here. Treating it as if it's not genuinely compulsory. Federal workers, there are fewer now than there were at the time, but more than 2 million civilian workers in the federal establishment were also ordered, and that was upheld by the federal appellate court in Texas. Other federal appellate courts, though, rejected, at least preliminarily, mandates applicable to workers of federal contractors. Then you have several private COVID vaccine mandates. This was a big hospital in Houston. Again, the federal appellate court in Texas decided there was no problem with this. There's an interesting one from our neck of the woods, Norwegian Cruise Lines. They wanted to demand proof of vaccination before you could disembark, or before you could embark on a voyage. But Florida, our legislature had prohibited, like legislatures in Texas and Alabama. So 3 states had banned so-called vaccine passports, and Norwegian felt that violated the company's constitutional rights, and the federal appellate court here in the 11th Circuit decided no problem. So that private vaccine mandate was unenforceable by virtue of state law. Now, the big question, going all the way back to Jacobson, is, does it violate the due process clause for a federal, state, or local actor to force you to get a vaccine, to get vaccinated against your will? Okay? Typically, you would ask, well, what's the fundamental right? Well, we all have fundamental rights to refuse medical interventions, even life-saving medical interventions. But Jacobson sure suggests that vaccines, as a historical matter, is not one of those things that people have a fundamental right to object to or to refuse. I think it's still an open question. I think that maybe you could fashion an argument based on the newer modern decisional law on a fundamental right of refusing health care, that should trump what Jacobson had decided. Next question would be, well, does this get in the way of your exercise of that fundamental right? Does it burden the right? And this recalls the early slide I showed you about, is it really that mandatory? Or is there enough flexibility in it that we might say it's not a big deal? It's just $5. Or it's just homeschooling or Zoom schooling instead. And then lastly, this is the strict scrutiny step. If you manage on the first two, does it serve a compelling interest by the least restrictive means? Well, that then becomes an interesting question about, let's talk about what kind of infectious agent we have here. What's the degree of transmissibility? Is it readily treated or not? Is it sterilizing immunity offered by the vaccine, or does it only reduce severity? So you get into really fine-grained questions about what's the nature of the item that the government would force you to take in these sorts of circumstances. Last, I promise, this is what got me going down this road, down this path. The media inquiries about not yet FDA-approved vaccines. This is that federal statute. Countermeasures to chemical, biological, radiological, or nuclear or pandemic threats during a national emergency. Individuals have to be informed of, I quote, the option to refuse administration of the product. That sounds like a federal consent right. Nobody else saw it that way. The Office of Legal Counsel, OLC, was asked by the Biden administration, is this a problem? And the Department of Justice, the top lawyers there said, no problem. Biden, though, didn't take that at face value and said, let's wait, and waited 2 months until the FDA finally approved the COVID vaccine to avoid getting into this issue. There were plenty of state and local and private actors who jumped the gun, who forced COVID vaccines before full FDA approval, and courts were asked whether or not that violated the statutory subclause. Every one of them found no problem, and most law professors who've written about this question have also not found a problem, with me the exception. Once you get full FDA approval, and I said this at the outset, that problem goes away, and then you revert to the deeper foundational constitutional question. Do you have a right of refusal under the Due Process Clause or not? And because there's still this open question about whether Jacobson versus Massachusetts, which remains 120 years later, the clearest signal on that score, whether that still qualifies as having precedential weight, that's the tough question that perhaps at some point courts will very directly confront. And with that, and I apologize for running a bit over time, I thank you for inviting me today. And I hope I said something reasonably provocative that'll get the discussion going. So.
Hi, thanks for that. That's amazingly complex and very informative and interesting. The current setting, even during the height of the pandemic, we were vaccinating against a disease that had roughly a 1 to maybe 2% mortality. Would the mandate decisions by the federal government need to be different if it had a 10% mortality? Or what if it had 100%? Would you address the issue of how the court should respond depending on the lethality of the agent that we're hoping to prevent?
And that's an important sort of fine grain. That's if you get to the stage of engaging in this balancing process under constitutional scrutiny, you would have to confront. So smallpox, that's one of the reasons some people think that Jacobson, the old Supreme Court decision, may not translate, because the mortality rate for smallpox, great deal higher. I don't remember, 30% or something like that. It was really, really quite scary. Although nowadays there are treatments against smallpox, so maybe it's not, but back in the day, it was a serious deal. There's no good answer to where's the threshold. It is a, it's a fairly ad hoc balancing process that courts would involve themselves in. But it is a fair point, so that if let's say that somebody effectively presented a substantive due process objection to the COVID vaccine mandates after it got full FDA approval, just to keep it clean, would that survive strict scrutiny? And given the number you mentioned in terms of lethality, and given treatments that were becoming available just as full FDA approval for the vaccine came along, I'm guessing the answer would be no, that you couldn't constitutionally justify that. Now, earlier in the pandemic, no treatments available, and greater uncertainty about, we don't know what the death rate is exactly and among which populations. So there's another question. Let's say instead of everybody's got to get a COVID vaccine, it's just school children. Well, in that subpopulation, the rates were a good deal more reassuring in terms of the dangers to that group. And you wouldn't have the same argument you see today about other types of school vaccine requirements. Get them early and they're good for life, because of course the COVID vaccines, it's short term. It's like the flu vaccines. It'll last you a season if you're lucky. It's not like the hepatitis B vaccine. Get them when they're young and coverage for the remainder of their life. So these are all to me, interesting medical practice, scientific questions that a court would challenge if they ever got to the juncture of actually having to do that sort of balancing process. And no courts have done that yet. They've always found a reason for dodging those hard questions. Now, that assumes strict scrutiny applies. If it's the more typical rational basis scrutiny, then the answer is the courts will defer to the legislatures or the regulatory officials' judgment. So if it passes the laugh test, that's good enough for the courts. So that if the legislature was on board with the numbers, okay, whichever way they cut, a court's not going to second guess that. It's only if you have a fundamental right that's been infringed or unduly burdened that a court would have to second guess potentially the judgments made by a legislative or a regulatory body.
Hi, June. I see you're online on Zoom. Do you have a question for the speaker?
Yes, thank you very much for a very comprehensive presentation. That's very important. Anybody who has read anything about the smallpox problem knows how difficult that was. That was when we first put on masks and we lost lots of people. I can't remember the numbers, but they're big. My question to you is, now I see no reason why Jacobson should prevail. But I think we have ways of mediating that with Zoom, so that if you're not allowed to go to school because you've chosen not to be inoculated, you could still attend class via Zoom. The same with a business or a professional area. Of course, in ordinary labor, you would probably not have that opportunity. But how do you see AI and the new technology being able to maybe moderate this discussion?
I'm happy to answer, but I also want to make sure we're sort of, if somebody wants to jump in or I start
Mm.
with, by the way, I didn't have to silence my cell phone at the outset because I'm one of the holdouts who refuses to get a cell phone. So I guess
Me too.
good for you. The tech fix to me, especially given research about distance learning, for example, it is a detriment. It is not quite the same as doing it in person. So that you're right, or it doesn't have to be Zoom. It could be a homeschooling or some, you know, that the options we have today are a good deal greater than the far more limited options you had in the 19th or 20th century. That's undoubtedly true. But you also have to be careful not to view them as ready substitutes. Just like, for example, you know, if you get a religious waiver, you might be told you don't need a vaccine, but you're going to have to mask. And I'm not sure. I mean, I get why, but in another sense, the masking may signal to others that you're a holdout, so that you may prefer not to have to do that either. But what you're touching on is what that first sort of more detailed slide I gave you, which is this question of what do we mean by compulsory? When is something genuinely mandatory? At what point is it you have no choice, as opposed to you have a choice? So, you know, forget cruising, instead you go hiking. Are those good substitutes for one another? I'm assuming not. Just like I'm not sure that hybrid or remote learning is really a substitute. It's a next best, it's a second best, it's a way of accommodating, but it's not ideal. But please, if anyone else wants to jump in on that score.
Well, my question to you is, does a small minority of people have the right to put the world's population at risk for a disease that is otherwise preventable? And the classic case is measles. 10 years ago, we had no measles in the US. We now have people dying from measles, and we know that unless we have 95% of the population immunized, we will continue to have measles. That's the public health statistics. We need 95% immunity. Now, for smallpox, there's none in the world because of vaccination. With COVID, the people who are vaccinated were not the people on the respirators. There's no question the COVID vaccine may not prevent you from getting it, but it will ameliorate the disease that you do get. So the question is, what legal right does this small minority have to put everyone else in the world at risk for preventable and treatable diseases?
And you make several good points. I want to make sure we tease them out. One is sort of system capacity. That's another argument in favor. You know, one of my last slides asked, does it guard against transmission or reduce severity? Many would say reducing severity is a compelling interest in its own right, even though it seems to be something only experienced by that individual, because then they don't have to go to the emergency room. They don't have to get into the ICU, leaving that space available for others who would. So that's an important point. Measles may be the best contemporary version of what smallpox was more than a century ago. Doesn't have the same lethality, but it's even more transmissible. So that's, and we are, I mentioned Canada. Canada apparently has 3 times as many cases as the United States right now. In large measure because one of the province, I think it's Alberta in the West, they don't have a school prerequisite. So there's no expectation that students show proof of the full slate of vaccines before enrolling in school. So you have, just like in West Texas, you have very low rates of immunization. And for some infectious agents, you can go under 95% and not worry. And of course, there's some agents that aren't truly infectious. You know, tetanus, rabies. I mean, we're not talking about your dog getting a rabies shot. We're talking about people. I've had the rabies shot, not because I was infectious to anyone. It's a treatment so that there's no or little transmission risk. You couldn't imagine justifying a vaccine requirement in those circumstances. So it's a sliding scale. There's no doubt about it. And your sort of fundamental conceptual point is allowing a minority to threaten others. That's Jacobson. That's social compact. That's all about we're in this together. Public health is an end of government. It's one of the most critical things that government does for us, because otherwise, if we leave everyone to their own devices, like in the free state of Florida, we're going to suffer the consequences as a community. And we don't want to turn public health into private health. So I'm with you there. But in terms of constitutional doctrine, I'm increasingly convinced that the Jacobson mentality of everybody has to be willing to sacrifice some of their freedoms for their I used it up. That I just sense that vision is kind of last century, right? So and that's a concern. In fact, I was telling folks over lunch, I'm teaching public health law in the fall, but I had to rename the course. And I'm not entirely sure why I had to rename the course. My paranoid suspicion is that public health has become a four-letter word. I hope that's not the case. I hope there's some other explanation, but it's not going to be called contagion in the law.
I have a question in terms of the gap between science and the development of law to deal with the new science. If you have an immediate outbreak of Ebola or bird flu becomes epidemic, there is a gap where the science might say that the consequences are dire. We need to have everybody vaccinated, and there's a time limit there. The law will catch up. And we will see what happens once the vaccine takes place, and then it may not be necessary for everybody to
with hindsight, you can.
yeah. So there's that lag there. Would we benefit maybe from legislation that gives science the go-ahead to say everybody has to comply for this small period of time because we don't know what the consequences are and we can't take the risk?
And that's the way it used to be done. You know, and again, going all the way back to Jacobson, there was a state law that empowered local officials in an emergency to go ahead and tell everyone, you've got to get the smallpox vaccine. Okay, we're not going to dither around. We're not going to wait, we're just going to give you the green light to do that. Make your best guess under conditions of uncertainty, and we'll trust the experts. We're moving away from that kind of vision. And partly that may be because courts also, with the benefit of hindsight, are becoming increasingly skeptical of expert judgments made in the trenches. I mean, there's this when the OSHA, that's the large employer mandate rule, it was called an emergency temporary standard, was first litigated. I still distinctly remember the first judge, it was Engelhardt in the Fifth Circuit in Texas, to get his hands on this. It was astonishing how this guy just, because of something he saw on whatever cable news show he was watching, he just knew better than the folks at OSHA, at NIH, at CDC. And this is something that's becoming more and more common. Whereas if you go back even 10 years, you would see much greater deference to expert judgments, legislative deference, judicial deference, you name it. But with the increased politicalization of these subjects, it's almost the opposite, that we don't trust persons who have expertise to make these calls. So yes, and it used to be that way. I miss it, but I think unfortunately we've shot past that point. But go ahead.
But would it be advantageous to have legislation that says that you have this window and not leave it to the courts?
Well, and in effect, the emergency use authorization is kind of Congress saying, we know things can suddenly go really bad really quickly. We might have a bioterror attack. Somebody said smallpox is gone. Well, actually, there's some vials that are sitting around in labs somewhere. And there was concern early in the Bush administration when anthrax spores were circulating domestically. What's next? Somebody's going to unleash smallpox suddenly. They're going to weaponize it. So Congress decided we need a rapid response mechanism. We can't wait a couple of years for the FDA to give it the green light. We need to be able to rush things out given high needs. And then, and the courts, there were preemption, there were immunity, there were various safeguards built in so you wouldn't get the second guessing you're describing. But that's an old, more traditional legislative response. And I think that's falling by the wayside nowadays, unfortunately.
Can you say that there will be preference in hiring, promotion, and raises to people who come prepared to show that they have been vaccinated, particularly, let's say, in a retirement community where people are more vulnerable?
So, and this is a great point. We're talking about compulsion. You're suggesting instead of a stick, a carrot. Let's incentivize. I don't know if you remember early in COVID when the vaccines were first showing up, there were some wild incentive programs. A shot in a beer, I think that was New Jersey, or a month's worth of subway tokens, or there was a lottery for free college tuition, or all sorts of weird things were being suggested. I hadn't heard of an employment-based one, but that makes perfect sense, that you would credit someone for making the extra effort to get that vaccine. I must say, I find it astonishing that rates of seasonal flu vaccination or immunization by healthcare workers are historically so low. It's like 55 or 60% on average. You would think that that's a population who would, just for their own self-protection, given they're circulating among patients, but also ethically in protecting their patients, they would bother. And usually it's not even a bother. They have carts going around the hospital. Here, get your flu vaccine. There is this resistance. So I think incentives, they avoid the sense that anything's being forced on you, but historically they haven't worked very well. And there are also incentives just in the broader population. It used to be if you got your flu vaccine at Publix or CVS, you get a $20 gift card or something like that. Now they're cashing in because they get to charge your health insurer for the shot, but you're getting a free shot and you're getting $20 worth of groceries or what, they don't do that so much anymore. But yeah, it would be great if we could just encourage and, if necessary, bribe people to do what they should be doing. But what happens when that's not enough? Do you take it one step further and say, okay, we're done playing games here. We're going to force it on you. And that's when people push back. I mean, that's when you have this sense of something's being done to me and I don't like that. And that's where people become litigious. So, yeah.
Yeah, I'd like to address the religious exceptions. It seems that the court doesn't believe that religious freedom from the Constitution uh, requires a religious exception, and that it seems to be up to the states, depending upon their approach, to decide whether there would be a religious exception. Uh, but it seems to me that that's also an issue of conscience, and that under the current administration, it mandated vaccinations is an ideological issue, and that they would probably be quite happy if states extended the religious exception to those who just don't believe in vaccinations. And I'm wondering how that might be treated by the courts.
Many states in their school vaccination requirements included philosophical or personal belief exemptions. So it could be medical, it could be religious, it could be philosophical. The problem was too many parents had philosophical problems. So most states have taken those away. California had a philosophical exemption, and then you had a measles outbreak at Disneyland and they take it away. So what happens is you then have a spike in religious exemption requests, and more states sense that people were gaming the system. How did all of a sudden we go from 0.5% to 5% of parents having religious qualms? Well, it's because you took away their personal belief qualms, so they're just repackaging the same thing. It's not genuine. And then some states decided to push back against that, like New York did, and get rid of the religion. So you have maybe half a dozen states that don't even have a religious exemption. I must say, though, that the U.S. Supreme Court in the last 5 years has changed its tune dramatically. So that I suspect if one of these cases from a state that got rid of religious exemptions for school enrollment, for example, went up to the high court, it would be struck down as a violation of the free exercise clause. Why do I say that? It's because of the COVID closure cases where you couldn't assemble, you couldn't have more than 50 people or 10 people or whatever together at a time, and they closed churches as a result and other religious facilities. Many of those, half a dozen or so, went up to the high court under the shadow docket, and they were increasingly sent back as a violation of the free exercise clause. So reading between the lines here, even though and I say early, it was early in COVID with the Mills and the Hochul cases. Those were the 2021 decisions that said you don't need a religious waiver clause. If those came up 2 years later, you would. So nowadays, I'm fairly confident in concluding that as a matter of federal constitutional law, you always have to be able to opt out if you have a legitimate religious claim.
Yes, I just want to say, I think you hit the nail on the head when you said part of the problem is the erosion of trust in this country in particular, and experts and science in general. Do you have a sense of what the situation is currently in Great Britain and Western Europe in this regard? You mentioned Canada.
And I didn't mean to pick on Canada. I mean, every country has gone through a version of this thanks to the pandemic. The one country that stood out for responding and showing faith in institutions was Australia. That the Australians, and to a lesser extent New Zealand, that those countries seem to have weathered this better than most, partly because they never lost faith in their establishments. Okay. I mean, the UK is a special sort of situation. Most of my relatives are in Germany. I haven't gotten the sense that they've seen anything quite like what we've seen in this country in the last 5 or so years, or in this state in the last 10 or so years. But you know, even there's more, I suppose, there's a greater willingness to question physicians, scientists, others who are in positions of, you know, based on their, you know, particular training and insights that perhaps everyone's become a cynic, I suppose. Even I've become more cynical in various ways. I don't know. Do you have your question obviously springs from a sense that something's different there, but do you want to take the mic?
Well, it's just on a personal basis, this is what really concerns me, is the erosion of trust in science, in particular, authority in general. I think it's very serious.
Well, I was just reading something this morning that blew my mind. The new director of CBER, the Center for Biological Evaluation and Research, that's the FDA group in charge of vaccine approvals. He lasted 2 months in the job. Vinay Prasad, actually a serious scientist. Okay, now a little bit, you know, to the right with regard to some of his policy positions, but his scientific credentials were spot on. The New York Times explained why he got lumered. It's because he, in old podcasts, had said unkind things about the current occupant of the White House, something about a voodoo doll, I think. Okay, but I'm sure whoever Laura Loomer finds to her liking to decide which vaccines should and should not be approved is going to scare you more than this guy Prasad would. So there's something wrong to my mind. And I apologize for editorializing. I don't want to, but I'm with you there. So
let's say Jane Doe refuses the COVID shot and is later determined that she was the source of an outbreak among her fellow workers or friends or family. Is she at risk of culpable negligence charges for damages or criminal negligence?
that's a great question. I teach torts. So the negligence part, could you be held liable, civilly liable? Based on what I've seen, that would be a hard sell. It would be very challenging to make that work. Now there are, and I include these in my public health textbook, there are limited illustrations of persons who know they have an STI and fail to disclose that to a partner and infect the partner. In fact, there's a Florida case like this. You can be held civilly liable for personal injury for the harm done, medical expenses and so forth. And many states until recently had special felony provisions for HIV. If you knew you were HIV positive, okay, and you weren't disclosing that to a partner, you could spend 20, there's an Iowa case, 20 years in jail. So there is some precedent for what you're describing. Now in the COVID cases, the closest I've seen are businesses that force workers to show up while sick, that know a worker is sick and still obligate the worker to be there because they're essential, that a victim, let's say a customer who suffers an exposure, a victim has a claim against the business. Okay, they're going to be a more interesting kind of deep pocket in any event. Whereas a family member or a coworker, that's typically not the sort of thing that's going to lead to any meaningful.
About a schoolmate?
Parents of schoolmates. I gave that as an exam question many years ago. An anti-vaxxer parent sends their kid in and infects a classmate. It's a neat question. In terms of the decided cases in this country, unlikely to work. There are too many obstacles to successfully pursuing that. Now, maybe, I mean, going back to the idea of incentives, maybe it's a disincentive rather than a compulsion, but you should know if something bad happens, you're going to suffer the consequences financially. Are you okay with that? Maybe people will straighten out their approach. I think that there's some merit to that, but so far at least, that's also not been the way to go in this context.
Kind of like to go back to the question of whether the federal government has the authority, obviously legally, constitutionally, to impose behavior on the entire population. When we were growing up, that federal government mandated a peacetime draft. Now, that didn't apply to women, but it was universally mandatory for a huge population. If the federal government has the authority to impose a draft or to impose taxation, why does it not have the authority to impose vaccination in the public interest?
Those are different headings in Article 1 of Congress's power. That's a start. I mean, the conscription angle, as I said in the presentation, Jacobson did that very explicitly. In fact, one of the infamous follow-on decisions that relied on Jacobson was Buck versus Bell. Mandatory sterilization of the feeble-minded in 1927. The only support cited by Oliver Wendell Holmes was the Jacobson decision and a reference to the military draft. So you can put that to various uses. So national defense, one interesting angle is to suggest, and we've seen this actually suggested in the current administration, that what it means to protect against invasion, okay, it's not just immigrants, it's also viruses, that might be a basis for a nationally uniform response. Now, that's not, I mean, in the Biden administration, it was, let's do the workplace, OSHA, let's do healthcare institutions, let's do our own workforce, let's do the military, so civilian and military, and let's also twist the arms of people who want to do business, like government contractors, make sure their employees are covered with vaccines. That's a very sort of scattershot way of accomplishing it. You're just saying, well, let's just cut through all the baloney and just make it Congress passes a law. Congress has not passed such a law. Congress passes a law that says everyone in the country must get vaccinated. Interstate commerce, you can make an argument. Yeah. It's hard. It's probably going to be a stretch. So the real answer is, as a historical matter, this is sort of federalism, states' right. These have typically been state issues. Education, health, family law, stuff like that. The federal government has generally stayed out of and left for state control. I mean, the feds have influenced it in all manner of ways, including by dangling a lot of money in front of the states. But in terms of, I thought what you were going to do is the broccoli issue. Make everyone eat broccoli. I don't know if you remember that. Obamacare, right? When it went to the U.S. Supreme Court, the argument was you can't do that. So the U.S. Supreme Court said, this was the NFIB versus Sebelius decision, Chief Justice Roberts, his angle was, okay, it's not the Commerce Clause, it's the taxing power. So Congress used its taxing power to justify sort of a health care mandate, a federal health insurance mandate that individuals had to abide by. So it wasn't like Congress saying everybody must eat broccoli. I do twice a week, but I think people should, but that's kind of their business.
Last question over there.
One of the, my name's Dave Wilson. One of the issues we often hear from anti-vaxxers is what I call junk science. There was a lot of discussion about vaccinations causing autism, and it's proven to not be true, but there's a lot of that is fueling this. Have the courts ever dealt with that at all?
Well, sure, they've dealt with it, collaterally, you might say. And you say junk science, I mean, our Secretary of HHS has promised to tell us in 1 month that autism presumably is caused by MMR. He just withdrew the federal recommendation for thimerosal, which is kind of a symbolic gesture. There are very few vaccines that still use thimerosal as a preservative. So persons in charge of our federal expert agencies are hook, line, and sinker down that path. And part of the problem is there are any number of judges, federal and state court judges, who are like-minded, I'm afraid. This becomes kind of it's a matter of reasonable or unreasonable minds might disagree, as opposed to there's a final kind of everybody's on board with this vision, which goes back to the, where did we go off the path when we made these questions not questions for scientists to resolve among themselves using their normal institutional mechanisms? I mean, now even peer-reviewed journals are being told by the current administration, we're not going to let our scientists publish with you because we don't trust you. We think you're all being paid by the pharmaceutical industry. They actually are, but they're still better than the alternative. So it is clearly part of the problem. In fact, Henning Jacobson was unmistakably, he had bought into the anti-smallpox vaccine minority views of his generation. One of the things, though, that I mentioned in my textbook, 1 year before he said no to the smallpox vaccine, 9 kids died in Camden, New Jersey of the smallpox vaccine. It was contaminated. Well, that was because it wasn't federally licensed. Congress the next year decided, okay, we need to get some federal licensing. So even if you trust the experts, even if you believe that everything is done to safeguard, there are still going to be occasions where people might have legitimate qualms. And I don't want to dismiss that too easily. So I have bought into that there's no autism connection for any of these things. I think I've made that very clear in various writings I've done. But at the same time, just like I don't think anyone has a genuine religious basis for rejecting vaccines that are produced using cell lines that have been derived from aborted fetal tissue. To me, that's way too attenuated. Or that long-acting contraceptive products are abortifacients. They are not. But there's so many misconceptions circulating, and they're circulating much more quickly these days. They're getting magnified much more readily. They're drowning out, persons who have calm, reasoned reactions to these sort of things. That's the new environment that we're in, and we have to sort of work within that, I'm afraid. Anyway, I appreciate your attention.
I want to make one comment, and then I'm going to let you. I've been doing some work with the Court of Federal Claims, which is the court that if people bring takings cases against the government, if they feel that the federal government has done something wrong. And someone mentioned that they've been flooded with vaccine cases. And I was like, what? What do you mean vaccine cases? So the National Vaccine Injury Compensation Program was a federal statute passed in 1986 to provide compensation for any no-fault compensation program for providing monetary compensation to any person allegedly suffering injury or death as a result of the administration of certain compulsory childhood vaccines. So it's interesting that we have, back in the 80s, we set up a program for dealing with that. But anyway, that's my last comment, and now I want to thank
Well, and let me just say in response, that was to stabilize the marketplace because there were too many tort claims and companies were abandoning the childhood vaccine market. So Congress had to say, don't worry about it. We've got you covered.
Covered. Great. Well, thank you so much, Lars. I learned a lot.